Imagine the vibrant chaos of a summer festival. Beneath the music and laughter, a hidden web of legal duties, liabilities, and potential catastrophes awaits. This isn't just entertainment, it's a critical case study for every lawyer, student, business owner, and manager navigating the complex landscape of event compliance and risk management. Sunfield Sounds, a sprawling music festival, is meticulously set up. Anna, the manager, oversees the preparations, while Ben, an employee, tackles lighting rigs. Clara, a food vendor, prepares her stall. This idyllic scene, however, is a ticking legal time bomb, demonstrating how easily oversight can lead to devastating consequences. Emily, a lawful visitor, slips on an unmarked wet patch in a poorly lit corridor. Sunfield Events Limited owed her a duty under the Occupiers Liability Act 1957 to ensure reasonable safety. The absence of warnings and poor lighting constitute a clear breach, mirroring cases like Wheat v. Laken and Co. Ltd. Later, young Frank, a child, trespasses into a restricted area and is injured by exposed wiring. While a trespasser, the Occupiers Liability Act 1984 might still impose a limited duty if Sunfield knew children might enter and failed to take reasonable preventative steps, as seen in Tomlinson v. Congleton, BC. Ben, setting up a lighting rig, lacked proper training and safety equipment. The rig collapses, injuring him. The health and safety at work, etc. Act 1974 mandates employers ensure, so far as reasonably practicable, the health and safety of all. This failure is a grave breach, with severe implications for Sunfield. Ben's injury was exacerbated by a defective harness. Under the Employers' Liability, Defective Equipment Act 1969, Sunfield is strictly liable for injuries from faulty work equipment, even if the defect originated with the manufacturer. This highlights the critical need for rigorous equipment checks. Furthermore, Sunfield Events Limited failed to renew its compulsory employer's liability insurance. The Employer's Liability, Compulsory Insurance Act 1969 makes this a criminal offense. While Ben can still claim damages, Sunfield faces substantial fines and reputational ruin for this fundamental compliance lapse. Derek, a journalist, tweets a false rumor about Clara's food stall causing mass food poisoning. Clara's business suffers immediately. Under the Defamation Act 2013, Clara sues, proving the statement caused serious harm to her reputation, a threshold established in Lashow v. Independent Print Ltd. Emily, the injured festival-goer, was running in flip-flops despite safety advisories. The Law Reform, Contributory Negligence Act 1945 allows for a reduction in her damages, acknowledging her partial fault. This principle, exemplified by From v. Butcher, underscores shared responsibility in negligence claims. The festival's legal team faces a barrage of claims. The judge, in a dramatic courtroom, untangles the statutory duties, insurance lapses, and apportionment of blame. Emily receives reduced damages. Ben is compensated, with Sunfield liable for both defective equipment and insurance failure. Clara wins her defamation claim. Frank's claim is dismissed, as reasonable warnings were in place. This scenario is a stark reminder: legal compliance is not optional, it is foundational to every operation. For lawyers, it's a blueprint for litigation. For students, a practical lesson in tort and statutory duties. For businesses and managers, it's a critical warning. Understand your obligations, implement robust safety protocols, ensure comprehensive insurance, and train your teams diligently. Don't let your enterprise become the next cautionary tale. Review your compliance frameworks today. Ignorance is no defense, and the cost of negligence is immeasurable.